and welcome back to Come Geek Some. If you are new to the channel, please like and subscribe for all future content. Today we're going to be looking at two of the recent filings in the VM case, and some of them are very interesting. The one we're going to look at first is the actual VM response. So it's the plaintiff's response to defendant's motion to compel deposition and documents of Chris Slatosch. First amended motion to quash and a motion for sanctions. So this is 11 pages long. We're not going to read all of 11 pages. And the other video we have coming later today is actually the Funimation court costs, which is a staggering 125 pages. Again, they seem just to be trying to get as much money out of them as they possibly can. But we won't go over all the 125 pages. We'll just skip over some, because some of them are interesting, most because it's got affidavits of a few new people and a couple of other things. So let's get back to the plaintiff's response. To the Honourable Judge of said court, now comes Plaintiff VM and files his plaintiff's response in defendant's motion to compel deposition and documents of Chris Slatosch, first amended motion to quash and a motion for sanctions. Motion asking this Honourable Court deny defendant's motion to compel deposition and documents of Chris Slatosch, quash the defendant's notice of intent to subpoena him, and award sanctions to plaintiff in connection therewith. In support thereof, plaintiff would respectfully show the following. Number 1. Plaintiff asks the Honourable Court to quash defendant's notice to subpoena Chris, which seeks the deposition of non-party Christopher Slatosch. Plaintiff seeks to quash the deposition on the grounds that discovery is sought in clear violation of Sections 27 of the TCP&R Code, which suspends all discovery until the court has ruled on a motion to dismiss. Number 2. In addition to the grounds asserted above, the deposition sought is not relevant to a determination of whether plaintiff's action was brought to deter or prevent the moving party from exercising constitutional rights, and it's brought from an improper purpose, including to harass or to cause unnecessary delay, or to increase the cost of litigation, which we've actually talked about that quite frequently as well in a couple of other videos, mostly because a lot of people have seen now that Lenoir, he is literally trying to get as much money out of this as he possibly can. Then again, he is a lawyer. That is what lawyers do. Try and get the most money out of the person who's going against you or whatever. A matter already decided by this court. Further, the deposition sought is not relevant to plaintiff and his counsel's culpability in bringing and prosecuting the dismissed claims. Specifically, the testimony at issue was offered at a declaration in response to defendant's motion to dismiss. Number 3. Plaintiff asks the court to deny defendant's motion to compel deposition and documents of Chris Slatosch. Plaintiff further asks the court to award plaintiff sanctions pursuant to Rule 13 and 215 of Texas Rules of Civil Procedure and Chapter 10 of the TCP&R Code, on the grounds that defendant's motion to compel deposition and documents of Chris Slatosch, on the grounds that defendant's motion is frivolous, has not basis in law or fact, and because defendants have unnecessarily caused plaintiff to incur costs and attorney's fees in responding to the baseless motion. Now we're going to look at the background. Plaintiff initiated this proceeding seeking relief from defendants on the basis that defendants committed torts against plaintiff based on defamation, tortious interference with prospective business relations, civil conspiracy, and vicarious liability. Defendants responded seeking dismissal pursuant to Chapter 27 of the CPR Code, also known as the TCP Act. So the TCPA is what they're trying to look into now, because again, with the tortious interference, so in my eyes, they did do that because there is evidence. Obviously, there's text messages between Kamea Khan organisers and Ron, and Monica was supposedly speaking to him as well. But he did end up going there. He was invited back. So you can't really have that as tortious interference anymore for that part anyway. Other conventions, maybe, but we haven't seen any evidence as of yet regarding that. In its order, dated October 4th, 2019, the court granted defendants' motion to dismiss in full, stating therein that the court grants TCPA motions. Plaintiff VM's claims against defendants Funimation, Marchi, Rial and Toye are thus dismissed with prejudice. On October 23, 2019, defendants served plaintiff with their notice of intent to subpoena Christopher Slatosch, seeking deposition and production of documents from the same. At the time of serving the notice, the court had made no finding of good cause for defendants to seek such discovery, nor had the court signed any order to allow specified and limited discovery relevant to the motion to dismiss. Well, that's quite interesting to read there. So to me, that basically says they've gone and they're doing that just to waste time and to try and get something which they're not, by the looks of things, if I am reading this correctly, that they weren't allowed to do. Argument and authorities. The pivotal question is whether defendants were permitted, at the time of serving their notice of intent to subpoena Christopher Slatosch, to seek said discovery. The answer to this question is no. There we go. Defendants are not allowed discovery absent a court order. Number 8. Section 27 of the TCP&R Code provides in relevant part, except as provided by Section 27, on the filing of a motion under this section, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss. The exception referenced Section 27.006 provides on a motion by a party or on the court's own motion and on a showing of good cause, the court may allow specified and limited discovery relevant to the motion. Number 9. While the court has granted defendant's motion to dismiss in full, the court retained jurisdiction so that the defendants may submit evidence and briefing in support of an award of attorney's fees, costs, and other expenses incurred in defending the action, and appropriate sanction pursuant to the Texas Civil Practice Remedy Code. By the language of the order, the court has not made a final ruling on defendant's motion to dismiss because it must determine an appropriate award. So all this is very interesting now, and we do have a couple more pages to go, but they are mostly exactly the same. They're just saying, well, this is happening, that's happening. They do speak about the litigation and a few other things in the following pages, but what I will do, I will leave a link below to the actual documents, so if you want to read them, you can read them all in full. But we're going to just skip ahead to a couple here. We're going to skip ahead to motions for sanctions. Plaintiff has asked the court to award sanctions against the defendants and their counsel pursuant to Rule 13 and 215.1 of Texas Rule of Civil Procedure and Chapter 10 of the TCP&R Code on the grounds that defendants' motion to compel deposition and documents of Chris Slatosch is frivolous, has not a basis in law or fact, and because defendants have unnecessarily caused plaintiffs to incur costs and attorney's fees in responding to the baseless motion. So with that one there, it's exactly what we've all been talking about. You even got Lenoir stating it in one of his letters. He's like, oh, we're not doing this just to get more money. But they are. Everyone knows this. This is exactly what's happening. Number 21. Sanctions under the Rule 13. Plaintiffs seek sanctions against defendants pursuant to Rule 13 of the TRCPR. Rule 13 provides the signatures of attorneys or parties constitute a certificate by them that they have read the pleading, motion, or other paper that, to the best of their knowledge, information, and belief formed after reasonable inquiry, the instrument is not groundless and brought in bad faith or groundless and brought for the purpose of harassment. If a pleading, motion, or other paper is signed in violation of this rule, the court, upon motion or upon its own initiative, after notice and hearing, shall impose an appropriate sanction available under Rule 215 upon the party who signed it, a represented party or both. So it's kind of interesting. And I really think this is actually a very good letter done to the courts for VM, because it's literally just showing them, it's like, well, why are we doing this? Because they're not allowed. And we've even seen, Lenoir, he's like, oh, you should do this, you should do that. And he's almost like telling them what to do, which is very interesting. But we're going to leave it by there, saying, that is mostly what the entire letter states, and the paper, there's 11 pages. But it's actually signed by Ryan Sellers as well. So It's a very good little document that they've done and what they've sent to the courts, so it's going to be interesting to see how they respond to that one. If you are new to the channel, please like and subscribe, hit that notification bell for future updates, and I'll see all you lovely people soon.